Good, I guess, afternoon, evening, depending where you're at. It is Saturday, December 20th, and I am joined by the fabulous, all-knowing Michael Ausbrook. Hey, Michael, how are you? Sorry, Michael texted me, hey, send me the link. And I was like, oh my goodness. Should have kept that a secret. Don't tell Bob, guys. Don't tell Bob. My daughter was like, Mom, I need this and that. And I'm like, I'm about to go live. And then I kind of forgot that I was going live and still looking down. But Michael and I are here to continue with the appellate brief. And I know, Michael, you mentioned a couple things to me to pull up and look at for this. So I don't know.
Well,
if we'll pick
so Shay Hughes, who's a contract public defender up in Lafayette, put up a tweet giving a thumbs up to the Franks issue. So I thought I'd look into it a little more. And really nice case from the Seventh Circuit came up from just this past November 25th. And
I will pull that up. So guys, that we ended with actually the Franks issue. So it's a perfect place to start. And oh, 804. I didn't pull that one up. And I'm just gonna, I guess, pull up the screenshot portion that you sent, although I read the entire case and it was pretty interesting, but give them a little basis while I do that.
So what I mean, the Seventh Circuit is, I've been so lucky to practice in the Seventh Circuit. They're all really smart. Almost all of them are really straight shooters. And, you know, I certainly haven't won everything, but you always feel like you have a fair shot in the Seventh Circuit. You don't get any truly crazy opinions the way you do, especially in the Fifth Circuit and maybe in the 11th, and occasionally in the Fourth. You know, they're just really interested in the issues. I mean, this panel that decided this case, it's United States v. Felton, you know, it's two former district court judges and one former Judge Pryor, who wrote it, was a federal magistrate judge. She was also a public defender in Arkansas, I believe. And she was also an assistant U.S. attorney. So, I mean, these are experienced people without any axes to grind. They just call them as they see them. I don't always agree with how they see them, but I appreciate the approach.
Right. And in this case that we're talking about, it happened to be a drug case and some omissions that the cop made about the CI, but it just shows you how the court analyzes a suppression matter when it's tied to a Franks, you know, denial of a Franks hearing and what the court could do. So I'll read this part that you sent, Michael.
Sure.
To obtain a Franks hearing, a defendant must make a substantial preliminary showing that 1. The warrant affidavit contained material falsehoods or omissions that would alter the probable cause determination, and 2. The affiant omitted the information intentionally or with a reckless disregard for the truth. And to me, this even just this little clip of the holding that we're reading is super important here as far as, what kind of burden, what amount of evidence is necessary for Richard Allen to meet the burden of showing that it was reckless, a reckless disregard for the truth or intentional. So the court goes on to say, for the reasons discussed above, Felton has made a substantial showing that the affidavit supported the search warrant for the tracker was defective. Therefore, the only factor that remains is the inquiry into Inspector Brown's state of mind. And let me switch over here so I can scroll. Credibility omissions themselves, even in the absence of more direct evidence of the officer's state of mind, provides sufficient circumstantial evidence to support a reasonable and thus permissible inference of reckless disregard for the truth. We draw that inference here. Inspector Brown omitted crucial credibility information about the confidential source who provided the most relevant and specific information about Felton's alleged drug trafficking activity. We leave it to the district court, so in this case, substitute district court with trial court, however, to determine whether these admissions were deliberate or reckless. Because Felton has made a substantial preliminary showing required for an evidentiary hearing on his Franks challenge, we remand. Now, Michael, I see this as corresponding just to show that here they can use just the facts that now Liggett left things out or made false statements to meet that burden for either the initial burden to get a hearing for the permissible inference of a reckless disregard for the truth. Is you think that strongly supports that here?
Oh yeah, I mean, you just put together, and this is why hearing actually might not be necessary.
I was going to ask you about that, but go ahead.
I haven't fly-spec'd Rick's first interrogation by Liggett and Mullen, but if there's
He was
enough,
adamant in his first. You're talking about it in his interrogations.
yeah,
He was adamant, cool, calm, collected. Like, this was not me. It's never going to be me. I cannot explain what the hell you guys are insisting that you've got fingerprint, almost the level of fingerprint evidence that this bullet is mine. Can't tell you how that's possible because it's not. I mean, he was adamant and consistent.
but so for the Franks part of it, the important part is all the things that Rick told Liggett and Mullen, but Liggett was there, that then got changed in the PCA affidavit.
Yes, and you had
Or the PCA.
right. I mean, he said he couldn't remember what he was wearing, but he was probably wearing jeans and blue jeans and a black or a blue coat similar to a Carhartt. I mean, he definitely didn't say this is exactly what I was wearing, and that's how they made it sound in the affidavit.
I think he also didn't say he parked at the CPS lot, and I think they said that he did park at this. I mean, there are a bunch, as I said, I haven't fly-spec'd the things, and what I'm trying to say is, because Liggett was there at that interrogation, there are maybe enough things to conclude that he left those things out, at least with reckless disregard for the truth, because he was there. He knew what Rick had said.
Right. I see what you're saying, as opposed to him being told what some of the other witnesses said.
Right.
Yeah.
And I will say, so I was talking with Andy Copsa a little bit about this, and I find this a little bit confused for all the props I was given the Seventh Circuit. There's something that's a little confusing about this to me, and that is where they say we draw that inference here. In other words, the permissible inference of reckless disregard of the truth. We draw that inference here. If
Right,
they
I hear
draw
you.
the inference,
Right, why didn't they just, and I thought the same thing, and then I thought maybe they're saying we're drawing the inference enough to show he met that that initial showing.
and I think that's right. And probably sending a signal to the district court about what the district court ought
Yes.
to be finding.
Right. I agree. I thought that it was definitely giving them a signal, but that's what I wanted to ask you. Now, unlike the because we're not in the 7th district, guys. It is the federal court that is both Indiana and Illinois. Is it all of Indiana or some of Indiana, not the 7th?
No, all of Indiana, Wisconsin, and Illinois.
Okay. So we're in their state appellate court. So here they chose not to just rule, you know what, we find that there was a Franks issue and it should have been suppressed. They remanded it, going it back to the trial court to have the hearing it didn't have. So we talked a lot about that being a likely or possible outcome here in Richard Allen's case. But in your experience, can the appellate court just as easily say, we're deciding that Franks issue?
Oh, I think they could. Again, I mean, this is maybe the perfect case. I mean, you take, again, what we have is we have Liggett's, we have the interrogation. Liggett testified at trial. I don't know exactly what he testified to there. In other words, we have some things Liggett has said along the way. If those, any of those, enough of those things contradict what he put in the probable cause affidavit for the search warrant, that might be enough to come up with intent for an appellate court to actually come up with, you know, we're gonna make the inference conclusively.
And not even send it back for a Franks hearing. I see what you're saying. Because I think with the other stuff that he left out, you could, you very easily get to the, meet that initial burden that he was reckless, at least reckless, disregard for the truth, with leaving out the other important parts of the statements. But I hear what you're saying, where he was involved in those interrogations and he misled the court about what he was told. That could take it, outside of a remand situation where the court's saying, all right, we're making that determination. It's interesting.
So, and the substantial showing thing is sort of interesting. Obviously, Franks v. Delaware, if the substantial showing language comes from there, is 1972, I think. There's, courts, for good or for ill, reuse language and standards all the time. And the substantial showing thing comes up, and I'm wondering whether Congress had this in mind to get a certificate of appealability. So in a habeas case, you don't get to appeal automatically if you're the petitioner. You have to get a certificate of appealability either from the district court or the Seventh Circuit, and to get one of those, you have to do what? Make a substantial showing of the denial of a constitutional right. And the Supreme Court has said a substantial showing is a pretty low standard. It's if reasonable jurists could disagree about
Right.
it.
Now,
and I'm not saying, I don't know that that's ever been applied in the Franks context.
Ask. Right.
And maybe I'll go look at that and see if they've imported that. But substantial showing in one context should probably be substantial showing in another.
Right. Unless there's something where they've applied it differently. That's the argument.
I mean, people also have to realize that legal language is maybe even more than occasionally ridiculous. Well, my favorite example is probable cause. There's nothing probable about it. This is the lowest standard. It's the lowest standard of anything,
Right. Well, going along with that, I'm going to pull up the rule, the trial rule 27 that you mentioned to me. Actually, I might just be able to do it like this. No, it's not letting me.
Yeah. So trial rule 27 provides a means by which, while something's on appeal, you can do a deposition.
I'm going to pull the rule up now. And I'm just going to read the pending appeal part. So we're talking about this in regards to, because this still relates to the section that we just read, section 1, dealing with Liggett specifically, and, you know, whether he was a reckless disregard for the truth or he did intentionally misled the court. So on an appeal, and this is Indiana's Rule 27, if an appeal has been taken from a judgment of any court or before the taking of an appeal, if the time therefore has not expired, the court in which the judgment, well, let me ask you that. If the time therefore has not expired, so we would consider the time while it's pending that's still incorporated in this?
Yeah.
Okay. The court in which the judgment was rendered may allow the taking of the depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in such court. In such case, the party who desires to perpetuate the testimony may make a motion in the court for leave to take depositions upon the same notice and service thereof as if the action was pending in the court. The motion shall show 1, the name and address of the person to be examined and the substance of the testimony which he expects to elicit from each, the reason for perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid a failure or delay of justice, it may make an order allowing the deposition to be taken and may make orders of the character provided for by Rule 34 and 35, which do we need to look at that, or it doesn't really matter?
No, I don't think so.
And thereupon the depositions may be taken and used in the same manner and under same conditions as are prescribed in these rules for depositions taken in actions pending in the court. This rule doesn't limit the power of the court to entertain an action. All right, so let me ask you this, because we've told all the people, hey, when you're doing an appeal, it's not based on new evidence. It's not based on something someone didn't say before. It's based on the trial record. So in Illinois, we don't have depositions in criminal cases. So why is this rule available if on an appeal you're supposed to be limited to what's in the trial record?
So it's available because what happens if it's remanded for a Franks hearing? You're going to have to get Liggett's testimony about whether he recklessly or omitted stuff, reckless disregard for the truth, or whether he intentionally omitted this stuff, or intentionally or recklessly included things that weren't true.
So in that case, it would be actually for use in the trial court on remand, not for use in the appellate proceedings?
Right.
Okay, I see.
Right, and this case is already 9 years old. If something were to happen to Liggett, and I'm not hoping that anything does, but if something were to happen to Liggett, that would make things awkward. The other thing is by deposing him now under the trial rule. And if I were doing it, I'd go to McClelland first before going to the court to see if he'd agree to do the deposition off the radar. not make a public spectacle of it, because, once you file the motion, then everybody's going to know what's going on, right?
In a million years, I can't imagine the state would agree to let him be deposed when they don't know if what wouldn't they say, well, let's wait and see if they say we should have a Franks hearing.
Well, that might be what Gull says, but I think that the denial of this would be appealable, and I think it's a pretty good. So I think that McClelland would rather have this done on the
Down low
than
Okay, and that's the other thing I was just going to explain to everyone, that given the what you just explained to us, that this would be for, evidence gathering for a possible Franks hearing upon remand. The request would get made to Gull because it's the trial court that this evidence would be used in, and not go to the appellate court.
Right. I mean, you might get it back up to the appellate court if Gull denies permission
Right.
to do it, but. And again, I don't know. I don't know that I've ever seen an appeal of a denial of doing deposition, but I also don't really see how Gull could say no. I mean, yes, you can say anything. But the other thing is that the deposition, so, I mean, not only is there the problem of things happen to witnesses over time, there's the delay question. And if you wait until, the end of the appeal, I mean, we're talking about 2027 before this gets started. And the other thing is deposing Liggett about the stuff he put in his crafting of the probable cause affidavit. You will find out whom else he talked to. And so and maybe they'll be important enough to then also depose. I mean, that's kind of the way discovery works.
So another thing, sorry, go ahead.
No, you go ahead.
So another thing I was going to ask you, and for all of you out there, Andrea is doing a live this evening, so you should check that out. And then her and I are planning on doing a deep dive after we both do the initial go over the petition on our respective channels. So I might research this issue for that. But do you know, as it relates to establishing either a reckless disregard for the truth or intentional, what we saw in that Franks memo was the defense relying on other instances of misconduct, other instances of not telling the court the whole truth, omitting something, changing something. Should that be relevant in determining whether in this particular instance of the affidavit itself, that person was acting with a reckless disregard for the truth or acting intentional?
So you're talking about stuff that wasn't.
So the things in the Franks memo, they spoke of other situations outside of the actual affidavit that shows, look, this investigation has a history of misconduct, of missing evidence, of misleading people, of, things like that. Is that something that the court should take into consideration when trying to determine whether or not the defense has met its burden of showing either an intentional act, intentional wrongdoing in the affidavit itself, or a reckless disregard for the truth?
So are you talking about things that were not mentioned in the brief?
Yes.
So my guess is, this is a version of courts are going to do what they're going to do. My guess is formally not in the appeal, but I think that if there is a Franks hearing, that it's wide open for everything.
So, and I think that's more what I meant, is that in a Franks hearing, is that fair, facts for the court to consider other instances outside of the affidavit itself where the officer, the investigation in general has acted, engaged in some form of misconduct? Because I thought that made sense to me, why the defense was putting in other instances that fell outside of the four corners of the affidavit to show this isn't accidental, because they keep doing it in different scenarios again and again and again.
So let's take the Seventh Circuit model in Felton. If the issue on remand is Liggett's state of mind, whether his intention or his recklessness, then I think the hearing's probably limited to evidence relevant to that.
To
In other
Liggett
words,
specifically.
you could certainly get in other things about what Liggett knew or about what Liggett did that maybe weren't in the appellate brief, certainly that would show up in a deposition. And yeah, I mean, anything that goes to his state of mind.
Well, but what I mean is, like, let's say, for example, because I don't know the facts as well as Bob and you and probably a lot of people in the chat, but I'm gonna make something up. Let's say, for instance, that um that Lisbeth was the one who wrote over some of the recordings. He later on, after all of this, he lied about something else. Are you able to use those other actions that in this investigation where he has shown an intent to mislead, omit material facts, engage in some sort of misconduct, to say that goes to his state of mind, and you can use that to show in the affidavit it was intentional or reckless?
Oh, you mean like Nick McClelland's course of conduct approach and the contempt stuff?
Yes, exactly. Yes, his course of conduct.
Absolutely.
All right. That's what I thought. I haven't seen it. I wanted to get your opinion on it, and hopefully we flesh that out for you guys out there. There's a lot of things. Right, exactly what Erica says.
Well,
Show a
I
pattern of
mean,
behavior.
do keep in mind we're dealing with Gull here, and she lets in all Nick McClelland's hearsay and keeps while sustaining his hearsay objections on the other side. I mean, clearly correct hearsay objections by the defense.
But based on what you're saying, it seems that if she were to exclude, and again, we'll keep it limited to Liggett's pattern of behavior in this case to show dishonesty in this specific instance, exactly like Erica M. Restated it, and she excluded it as not relevant. It doesn't matter that he lied 2 weeks later. Doesn't matter that he hid evidence. I'm making things up. That he hid evidence 2 weeks later. The appellate court would say, in your opinion, no, that's relevant to his state at mind at that time because it shows a pattern of misconduct in this case.
Yeah, because you can. So let's call it, technically, I suppose it would be 404B evidence, other acts.
Right.
What can you use other acts for? You can generally you can't, but you can use it to show what? Intent.
Right. Yep. All right, because I think that was some criticism, if I can recall, of people like, wait, why is the Franks memo, and maybe even of Gull herself, talking about all these other instances of misconduct? Well, as Andy said, how the hell are you supposed to prove someone's subjective thinking, but to show that he keeps doing this kind of shit? So you can't say this was just an oversight.
Well, I mean, look at the Brian Walsh trial. I mean, prosecutors have to show people's state of mind all the time. I mean, they showed an intentional killing of Anya Walsh by showing what? A whole course of conduct. I mean, and the jury was allowed to infer that the murder was intentional. Now, maybe that's going to be appealed, and we'll see. And
right.
But people have to show state of mind all the time. I think I just think getting Liggett deposed would be an incredibly smart thing to do, and it might lead to other stuff, and time's a waste. And the thing that people may not understand, evidence rule 804 B1A makes depositions, if a witness is unavailable, that it makes depositions non-hearsay. It makes them admissible. So if something were to happen to Liggett and they had his deposition, they could use it.
Right. And you sent me a screenshot of another rule. Is this a good time to pull that one up?
That's the rule 804B1A.
Okay.
That's evidence rule 804B1A.
Whoop. This is doing, it's showing, I don't know, is it showing that or just showing the little screen? Yeah, hold on. Hold on. I don't know why it's doing that to me. Oh, I know why. Okay. Because I had to click open with preview and I didn't. Okay. So hearsay exceptions. The following are not excluded by the hearsay rule if the declarant is unavailable as a witness. Former testimony. Testimony that any was given as a witness at trial, hearing, or lawful deposition, whether given during the current proceedings or different ones. And B, so that's an and, is now offered against a party who had, or in a civil case, whose predecessor in interest had an opportunity and similar motive to develop it by direct, cross, or redirect examination. So that, and those are the reasons we can do depositions in Illinois. It's usually like somebody's sick, there's like a real reason to think that they might be unavailable. But that's what Michael's saying here. If God forbid something happened to Liggett and he became unavailable, we've had other witnesses, officers, spontaneously deceased in this case, or oddly deceased in this case. But if he became unavailable, that his deposition testimony would still be able to be used. So Michael's pointing out that that's another reason to take that deposition. And like you said, to avoid delay, do it quick.
Well, and it's true it's true. The same thing goes for any witnesses who might be useful at a retrial or in a post-conviction case. I mean, they should be getting those people deposed.
All right, so I think that brings us up to speed on the section that we ended on last time, section 1.
Let me say this about Frank's cases in Indiana. So, I came up with Felton, the Seventh Circuit case we were talking about, just by doing a quick and dirty search on Frank's hearing and remand. And Felton comes up. You do the same thing in the Indiana cases. There are 3 cases that come up. 2 of them really have nothing to do with Frank's. The third one's a Court of Appeals case in which a lawyer was alleged ineffective for failing to ask for a Frank's hearing. And the Court of Appeals doesn't even discuss that. So there's literally maybe maybe a different search.
I just did.
Time on it might produce a remand, but I at least immediately didn't find a single case in which an Indiana appellate court remanded a case for a Frank's hearing.
So I just did Frank's in the same sentence as remand, and only 2 cases came up. And I did it in the same paragraph, and this is just in Indiana. And 3 cases came up, but this is like not using Frank's in the same as a Frank's hearing. So
right. So it doesn't happen here.
Yeah. All right. Wow. So, and then just because it's highlighted and we said it before and we'll say it again, I still think that it's a fair argument to make that by the court granting a Frank's hearing to the new attorneys that she appointed, she was, for all intents and purposes, acknowledging that a burden had been met that warranted a hearing, that a hearing was warranted for whatever reason. which is why they included this little sentence here about it's telling that the trial court was willing to schedule a Franks hearing when, when the new lawyers were there. All right, well, we'll move on to 3. So,
Yeah, I mean, I might have spun that out a little more by telling Libreto and Scremin that they could have a Franks hearing if they wanted one. That constituted a judicial finding that the substantial showing by Franks had been made.
I mean, that's exactly what I'm saying, and I do wish it was fleshed out more, but I mean, I think it's here enough to say it in oral argument, right?
Yeah, I mean, I don't think logically it's necessarily so, but I don't think legally it's necessarily so, but it's absolutely an argument.
Yeah, I would have made it. I would have made it for sure. Okay, so bear in mind that as of right now, I'm looking at my PDF document of this and not the chat or anything else. So, Michael, if you want me to stop, if there's anything you want to say or whatever, just shout out at me. Shout out at me. Okay, so this is the second issue. The trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in maximum security prison. And it starts out with a nice little quote. I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There is only one's mind, which can begin to play tricks. Was that a dream, or did it really happen? One begins to question everything. Nelson Mandela. Now, how typical is it for someone to incorporate something like this in a brief?
I don't know. I do it occasionally. I mean,
I find it effective.
Yeah. Yeah.
All right. I've never thought to do it. Maybe I'll start to think about that next time. All right. So they start out by talking about how solitary confinement is a form of punishment. And here's my issue with this just in general. And I think it's let me see what section 2 is. Maybe I'll wait till we get to the standard. But I just think, that this requires applying the law in a way it's not typically applied, because typically this results from state questioning, pre-trial or in a police station. So, applying it to this situation, they do a good job of it, but I think we could have seen it a little bit more, and I'll point it out when we get to it. But solitary confinement is a form of punishment, and depending on its conditions, even torture. By 2023, when Allen was held in solitary for 13 months, it was well established that prolonged isolation causes psychological pain, suicidal ideation, and psychosis. To protect inmates from psychological harm, the IDOC strictly prohibits solitary confinement over 30 days for anyone with serious mental illness, SMI, and requires transfer if SMI symptoms appear. Now, that transfer, they don't mean into Gen Pop, they mean to some sort of mental health ward, I would assume, Michael.
So Newcastle has psych facilities, Newcastle Prison, and maybe Wabash Valley. I'm not sure. Maybe Miami. I'm not sure about that. I know Newcastle does.
All right, but it's clear you got to get them out of solitary. When Allen exhibited the predictable symptoms of psychological pain, confusion, and psychosis, IDOC administrators refused to transfer him to a mental health unit. When Allen's attorneys informed the court of his dire condition, the court also refused to move him, and the prosecutor delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. Now, how important do you think that just that one sentence is that ties the prosecutor in here?
As context, I think it's incredibly important. I think everybody.
Does it make it more state action that it was involved in delay? He just blew it off, mocked it, but then was actively collecting evidence that resulted from it.
So I think what they're setting up here, and I think they do it effectively, it's actually collective state action. It's the department. There's a case called Chief Justice Rush wrote called Becker v. State, and it basically begins off, the state is the state. One agency is no less the state than another agency.
Right.
And so we've got Gull, the state. We've got the Department of Correction, the state. We've got Gull, the state, and now we've got McClellan, the state.
Right. And then they get how what's her name? The psychologist is the state. The question for this court is unprecedented but simple. Should the state be able to benefit from Allen's psychological pain that their deliberate indifference to his mental health caused? Thank you, Scout. I begged Scout to bring me water. I'm like watching my water slowly go, and I'm like trying to take little sips, and she brought it to me. Human decency provides the answer. No. The standard of review. An appellate court reviews a suppression denial for substantial evidence of probative value that supports the trial court's decision. It considers uncontradicted evidence favorable to the defendant and reviews legal issues de novo. And as we said before, that means brand new on their own. The voluntariness of a confession is a legal issue. Allen moved to suppress his statements made while in solitary confinement, which the court denied. The court reasoned the statements were voluntary because Allen failed to show they resulted from psychological coercion or interrogation. Now, tell the people why that is an outrageous statement. Just as far as the burden on voluntariness for suppression.
Well, under Colorado v. Connolly, the state has to prove, by at least as a matter of federal law, the government has to prove the voluntariness of the confession by a preponderance of the evidence.
Right. So, if the judge is using the wrong standard, I think that's something that warrants consideration as well. But the court found Allen's detention was intended to protect him, and that while he suffered from major depressive disorder and anxiety, he did not have SMI, so a serious mental illness, that would render his statements involuntary. So it sounds like she's acknowledging he had an SMI for the purposes of his ass shouldn't have been in solitary for longer than 30 days, but not enough to render his statements involuntary. Is that how you would interpret that ruling by Gull?
No, I don't think she found that he had SMI.
Well, but didn't they establish a major depressive order?
That's the MDD.
Okay, so I was taking it to mean that he did not have SMI that would render his statements involuntary, but you're taking it to be she found he didn't have a serious mental illness, period.
I'm saying that whether he had let's assume he had SMI, it wasn't sufficient to render them. I don't think there's any actual finding that he had SMI, but it just wasn't enough.
Okay. I was taking that, well, he suffered from it, but I hear you. I hear you. In addition, the IDOC records and videos like those admitted at trial, Allen proffered an order and settlement from the Indiana Protection and Advocacy, that's the IPAS, VIDOC, that the trial court excluded from the suppression hearing as irrelevant. In 2011, the Southern District of Indiana held that IDOC's housing of SMI inmates in solitary constituted cruel and unusual punishment, violating the Eighth Amendment. SMI includes delusional disorder, psychiatric disorder, and MDD. Segregation is harmful to prisoners with SMI due to a lack of social interaction, significant sensory deprivation, and forced idleness, leading to decompensation and psychological pain. An inmate decompensating from solitary may experience hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, and engaging in self-injury or suicide. Suicide watch further exacerbates the illness. The severe conditions in segregation units caused a predictable deterioration of SMI prisoners' mental health, and the IDOC has explicitly observed, diagnosed, and noted patient decompensation. The IDOC knew these effects occurred even in non-SMI offenders. Before a hearing on relief, the parties reached a settlement, including an expanded definition of SMI that subsumed the court's definition. So here's what all of this gets to. Gull said it's irrelevant. It's irrelevant to determining whether he had an SMI that would render his statements involuntary. I think this does a very good job, Michael, do you, of laying out just how damn relevant it was.
So I think it's relevant to something even more important,
Okay.
and that is,
State
so
action.
they mentioned deliberate indifference above, and that's sort of that's
Yep.
kind of an Eighth Amendment standard for a bunch of stuff. But the IPAS thing is relevant to, it's not just deliberate indifference. The Department of Correction knew what the effects would likely be. In other words, there's intention here.
Right.
I mean, it's not just about, it's not just about, look, Rick's symptoms, you know, are real, and you know, even the IDOC recognizes this happens to people in solitary. They knew this happens to people in solitary. It happened to Rick Allen. They absolutely didn't do anything about it.
They knew it could happen, and when they saw the signs of it happening, they did nothing and pretended it was, and even then testified that it was fake and nonsense and bullshit. When
and that he was being treated better than other prisoners.
right, when they knew damn well, yeah, you're right, goes to an intentionality. The IDOC's policies refer to the settlement, which, quote, sets the policy's tone. An inmate with SMI can only be held in solitary for 30 days. If an inmate decompensates into SMI and is unlikely to return to general population within 30 days, transfer is required. Allen admitted Dr. Westcott's 127-page report. On August 21st, 2023, Westcott evaluated Allen, who had been in Westville over 9 months. He was, quote, terrified, unsure what was real, and wondering if he was dead, in hell, or waiting for heaven. He could not.
Go back up. It says he evaluated on August. Okay, August 21st. I thought you said April 21st. Okay, 20.
Yeah, that would have been even better. He could not recall weeks of early 2023, including playing with feces, confessing, or banging his head. He believed he had been drugged. Westcott cited IDOC records showing, quote, acute periods of confusion, paranoia, delusional thinking, cognitive slowing, aggression, and combativeness. During this period of loss of, quote, touch with reality, Allen confessed. Westcott concluded Allen's psychosis stemmed from MDD, his personality, and the well-known effects of solitary confinement. Allen was grossly disorganized, delusional, and paranoid. Objective testing ruled out malingering. So remember, this is under the section that the court, standard of review and additional facts. Okay. So that's what they were getting to. We're under Section 1 in general. Okay. So these are additional facts that they wanted for this argument. So now B, the trial court abused its discretion by refusing to admit the IPAS order settlement into the suppression hearing. Evidence is relevant if it has any tendency to make a fact of consequence in determining the action more or less probable than it would be without it. And that's Rule of Evidence 401. Here, the order/settlement makes it more likely Allen's psychosis was caused by his confinement. And as Michael pointed out, and that there was some intent on the part of the state. The order found solitary confinement causes all the symptoms Allen experienced. Allen was more likely to decompensate because he spent 7 months on suicide watch, an even more restrictive form of solitary. The order/settlement also makes it more likely Allen was subjected to psychological coercion by showing solitary causes, quote, psychological pain. It demonstrates state action. The IDOC placing and keeping Allen in solitary, knowing it causes this predictable pain. The order settlement shows extensively IDOC violated its own policy as it includes MDD in the MSI definition, restricting Allen's solitary to 30 days. Allen was harmed by the court's refusal to consider the order/settlement because it undermines the court's findings and conclusions. You want to say anything before we move on?
No, I mean, I don't think you can. There's not a stronger claim that can be made for that.
Agreed. So C, the state failed to prove Allen's statements made while gravely disabled were voluntary. So now, in the brief, they're putting forth the correct rule. The state failed to prove Allen's statements made were voluntary. 1, the U.S. Constitution. The state failed to prove that Allen's statements were not the product of psychological coercion. An involuntary statement obtained through state action violates due process and is inadmissible, quoting Colorado v. Connolly, the U.S. Supreme Court case on this. A confession is voluntary if it is a product of rational intellect and freely self-determined rather than overborne by state law enforcement conduct. State law enforcement can include psychiatric facilities and prison staff. Now, so this is where I want to talk about, typically part of what you're arguing here is, whether there was an interrogation, and I think they do get to it at some point. There's a case that they cite, but when you're looking at what happened here, even let's talk about the guards. If he's just making a spontaneous utterance, do you think there needs to be a little more, and there'll definitely be room for that in the reply brief, but to kind of apply the law to this kind of very unusual circumstance where you're not talking about what took place in a police station, or you're not talking about what took place before someone came and questioned the defendant.
Well, at least most of the statements, state action, they gave him Haldol. That's...
But they never asked him any questions. They never, although not talking about the psychologist.
So, if you go up, it has to be the product of rational index and rational in the Colorado v. Connolly.
The
confession is voluntary if it is the product of rational intellect and freely self-determined. You give somebody Haldol, that's state action. You don't need a rubber truncheon.
I know, but it's hard to me. You need to do a little more to apply this to the situation where the state's not asking any questions. For instance, he's on the phone with his wife. So that's not a typical scenario that this kind of legal analysis has been applied to. Would you say that?
Yeah, I don't know about the cases, but I mean, look, I don't think you can give somebody's, I mean, so they're at least involuntary. I mean, the state action part of it, I think they've showed that it's, or trying to show that it's state action by saying this is the Department of Correction, Gull and Cleveland.
All right,
Basically,
so
I
why don't
mean,
I ask you this way? Isn't it typically now we've got custody, he's in custody, but isn't like the first thing you touch custodial interrogation?
well, that's only no, that's only the Fifth Amendment Miranda. That's not due process and voluntariness.
So if it's voluntary, because usually they say if it's not, I, I mean, I just think so. You don't think that this is sort of a case of first impression as to applying the typical standard, questions and legal application, standards to determine voluntariness in a situation where the defendant is not being questioned by anybody.
Yeah, well, I mean, there's certainly cases on voluntariness. For instance, I don't think that a statement, I mean, it involves conversation, but it doesn't involve questioning. I don't think that there are certainly cases saying that a statement, a confession issued after a threat of pursuing the death penalty, I
So I
don't think that that's admissible, but and I think that threat makes it involuntary. It's not a question of the questioning.
right. There's one of the cases he cited that I looked up, and the um the issue was like the warden went and asked him questions, the so it was the Townsend case, which I think they cite at some point. Maybe I'll wait till it's right here. So I looked at Townsend, okay, because I'm like, all right, what, because here it says state law enforcement can include psychiatric facilities and prison staff. So in Townsend, during the course of an investigation being made by the warden, he approached Terry Townsend, then in a solitary confinement cell, and asked him about the riot. So you had some questioning by the warden there. Um, you had some other factors that that made it a little bit worse. He was an illiterate youth who had been in prison about 2 years. He was in solitary confinement, was suffering from a head wound that he received the preceding day, which had rendered him unconscious and for which he had received medical treatment during the interim. So the court there said that in testing the voluntariness of the confession, it is necessary to look to the conditions under which it was made. So and that's what we're doing here. Um, and they went on to say that the um and this I thought was good language here. He was in solitary confinement, suffering from a head wound. Da, 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 da. Hold on. According to Terry, when a prisoner was subjected to solitary confinement, he was stripped of his clothes and placed in a dark cell on a diet of bread and water. The cell contained only the most primitive sanitary facilities and a board for a bed. State witnesses did not attempt to describe the conditions of Terry's confinement, so we must accept his testimony on the subject as true. Moreover, since solitary confinement for prisoners is considered additional punishment, it is common knowledge that solitary cells are not designed for comfort. But even there, you had the warden asking him a question. So
But the decision doesn't rely on the question. You really need to separate the Fifth Amendment stuff, Rhode Island v. Ennis. You need to separate the custodial interrogation from state action that makes a statement involuntary under the due process clause.
So are you saying there are situations where someone's given Haldol, not asked a question, and then because I think there was another one I did actually, another case that I read um that I took, um uh, where is it that I made a little clip of that I think involved Haldol, and the fact that it couldn't wasn't voluntary, but I couldn't find a case where no one was questioning them. And I understand what you're saying, you have to separate the 2, and maybe I need to dig in a little bit further, but most situations involve some form of the state using the the state, somebody asking a question as opposed to he's on the phone with his wife. But have you
You
seen
seriously think that a court would find a statement voluntary where they, hooked somebody's testicles up to electricity and just walked away and the guy started screaming confessions?
well, no, but that's I mean, I understand your analogy there, and I remembered what it was. It was a truth serum that case that I was reading, like, well, it would be where the court said this is like, and I think it was Haldol or something, like the equivalent of giving them truth serum and trying to say that it was a voluntary statement, but I must not have pulled that. I mean, I get your point. I get your point that if they're but you would assume in that situation they had just been questioning him and he had just not been answering. Like,
I think they're too. I don't think they're as connected as you do. The questioning might make it worse, but I don't think it's a necessary
element here.
Here,
All right.
it's a slightly different issue. The Seventh Circuit reversed a denial of habeas relief because in a case where the critical witness who ID'd the defendant had been hypnotized and the defense didn't know about it. And, it's not about voluntary statements, but the state changing your mental state. I mean, they change your mental state and then rely on what you say. And you look at the effects of Haldol. I mean, hallucinations, dullness. I mean, all kinds of things. I just don't know why you have to have questioning.
I mean, I don't think for like the credibility of it or the reliability of it. It's just, what I guess I'm used to seeing when you're talking about the voluntariness of a statement. So, but I get your distinction between the different constitutional amendments at play, so that your position is that voluntariness doesn't depend on whether there's any form of questioning from the state. Uh, but
I mean, look at Colorado v. Connolly. Respondent approached this is the syllabus. Respondent approached a Denver police officer and stated that he had murdered someone and wanted to talk about it. I mean,
then there you go. What was the state action?
It was so there wasn't any. It's involuntary. He walks up to the guy, the state. It's not a question.
There was no question. I get you. So what did they?
The voluntariness of it. So yes, maybe Mark and Stacy are trying. So there's involuntariness. It's even worse when there's state action causing the involuntariness.
Okay, because they started with an involuntary statement obtained through state action. I understand here we're talking state action was the conditions, all of that. And I guess in Conley they didn't require state action if he just walked up to the guy and confessed. I want to confess to a crime. Oh, it could be that the state's, disregarding his clear mental mental issues.
Yeah.
All right. So then hopefully then that's not an issue they've got to overcome. All right. State law enforcement can include psychiatric facilities and prison staff. Statements produced through coercive environment are involuntary regardless. There you go. Regardless of whether solicited through police interrogation. Months spent in solitary. So they cite to this Karaki case, months spent in solitary confinement, deprived of light, adequate food, and contact with the outside world is by itself sufficient to sustain a finding of involuntariness. Then you've got the Seventh Circuit. Staff at the state psychiatric facility created a coercive environment, rendering a juvenile's confession involuntary. The crucial element is police overreaching, going back to Connolly. So yeah, they did cite to cases that were didn't involve any interrogation. They weren't solicited by police. State actors use more, quote, subtle forms of psychological coercion. The defendant's mental illness is more significant in the voluntariness determination, but the state must still exploit the defendant's illness with coercive tactics, which they sure as shit did here. This is generally done through aggressive interrogation, but can be but exploitation can occur in other ways. So this is what prompted me to look up Townsend. It is difficult to imagine a situation in which a confession would be less the product of free intellect, less voluntary than when brought about by a drug having the effect of truth serum. All right, that's why I didn't have it in my clips of stuff that I pulled up. It's because I read it right here. And then I was like, oh, I want to read this one, hoping it didn't involve any, because that didn't necessarily involve police interrogation, but it involved a question. So that's kind of where I went. That's what got me in that little rabbit hole. But it does seem they also have cases that say you don't need any interrogation. For a statement to be involuntary, state action must be causally related to the confession. And I think here we have no question of it being related in that sense because of everything we just read. All right. The state's prolonged solitary confinement of Allen was state action. Contrary to the court's finding that Allen failed to prove state psychological coercion, it was the state's burden to prove Allen's statement voluntary by a preponderance of the evidence. To the extent Allen had a minimal burden of production. So for you guys out there, a burden of production is like you've got to put enough in your initial motion to raise the issue, to show that there was some, in this state, let's just say, state action, coercion, things of that nature. Just meet that minimal threshold for the burden to then shift to the state to prove that it was in fact voluntary.
Here's the good news about the way this goes. It just occurred to me, and that is normally the finding of voluntariness is going to be reviewed probably for an abuse of discretion because it's kind of an evidentiary thing. As I said yesterday, it used to be a question for juries, now it's a question for judges. It might go back for a hearing on the voluntariness of the confession, and also as far as reversal goes, at least the standard of review is going to be better because Gull applied the wrong standard.
Right. That's
So
why I was throwing that out there.
A mistake of law is per se an abuse of discretion.
Right. That's why I kind of was saying I wish they would have fleshed out more, but it's said there. So, I don't think it needs to be. But that's like if she made a mistake of law, then that's showing she, abused her discretion right off. So, and you're saying that could change things in the sense of it just being sort of pro forma as far as this issue because she made a mistake of law?
Oh yeah, I mean it's hugely important.
Yeah. To the extent Allen had a minimum burden of production, he met that. Prolonged maximum security solitary confinement in a pretrial detainee, especially after psychosis develops, is state action. Unlike the mentally ill defendant in Connolly who walked into a police station and confessed, Allen never voluntarily came into custody. He consistently protested innocence until enduring 5 months of maximum security solitary with no human contact except while chained or caged. Because it was pretrial, Allen's solitary was unprecedented and borderline, if not unconstitutional, punishment.
Oh no, it was absolutely unconstitutional.
Yeah, I agree. So,
No, Bell v. Wolfish. I mean, it's a 1979 Supreme Court case, and it's almost an exact quote. Keeping pretrial detainees in conditions that amount to punishment violates the due process clause.
yep. And then does Indiana not take issue with what I would be calling like a bare citation where there's no not even a little parenthetical with what happened in the case or the holding? Like, is this fine? Because in Illinois, they would take issue with this as a bare citation with no um details about the holding or the facts.
No, I mean, I think it's okay. I mean, normally you'd have a parenthetical afterwards with C. Litchfield, and I might say C. Litchfield because it's not controlling authority.
And
But
let's explain that because that was the other thing I wanted to talk about. You see, this is the 10th Circuit, and any federal court, tell the people why nothing in a federal, just give them the whole breakdown of what's controlling and what is not.
So Indiana courts are really only controlled by U.S. Supreme Court, so it's vertical. So U.S. Supreme Court opinions, Indiana Supreme Court opinions, and the Court of Appeals is bound by the Indiana Supreme Court opinions, and the trial courts are bound by both the Court of Appeals, Indiana Supreme Court, and Supreme Court decisions, U.S. Supreme Court decisions. The federal courts are an entirely parallel, separate system. And normally what happens in the federal circuit courts, so this Felton case on the Franks issues that came up today.
Right, that's the case I put up for you guys and read. Sorry, go ahead, Michael.
It's persuasive authority in the seventh, in Indiana, and for the most part, the Indiana courts do take the Seventh Circuit decisions pretty seriously, even though they kind of ignore some of my habeas wins, but we'll leave that aside for another day.
And that's because that's even more so with the Seventh Circuit, because that's the circuit that Indiana falls into. So that
absolutely, and there's a reason for that. And one of the prime reasons for the U.S. Supreme Court to grant certiorari, are when federal district courts, there's a split inside a circuit between the state and the federal courts.
Right. Which you're looking at right there with that case that you talked about, that it's 7th, but we noted that with Littlefield because it's the 10th Circuit Federal Court, so that's even less persuasive.
Yeah, probably less persuasive. I mean, the 6th Circuit would still, which is right next door to the 7th, would still, and right next door to Indiana, would still be pretty persuasive.
All right. So other IDOC safekeepers were in mental health units, not solitary. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme, citing a U.S. Supreme Court case. Also, Allen's solitary exceeded the 30-day IDOC policy restriction. IDOC knew it could harm Allen. When IDOC observed Allen's predictable deterioration, they refused to transfer him. And they cite to the transcript noting that keeping Allen in solitary when he was, quote, no doubt SMI was an administrative, not clinical decision. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5th emergency transfer motion citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. During this delay, Allen continued deteriorating. The prosecutor then mocked the defense's concerns as colorful and dramatic, while the same day IDOC found Allen, quote, gravely disabled. Knowing Allen was decompensating, the court refused to transfer him, putting the onus on the IDOC to provide care. It is fundamentally wrong to keep a gravely disabled Allen in solitary while using against him statements made to psychologists and suicide companions. And they cite to this Sims v. State, Indiana. And again, I made that green because in my mind, there at least be a parenthetical that said what happened in Sims, inmate held in solitary, something. But
So when something squarely stands, so you don't need to do that when, at least in Indiana, you don't need to do that when something squarely stands for the proposition that you're offering it for. I mean, the parenthetical, look, it would absolutely make it clearer easier for the court. They're up against a word count. There's nothing. They're not going to get dinged for having no parenthetical.
Okay, and as you said multiple times, and is also the case in Illinois as well, the courts will do what they want. I just see, that's another one that I see the courts rely on a lot. That there was just a bare citation with no, no details. So it's good that you don't think that'll be an issue here. 1 week later, the prosecutor sought all medical records, videos, and communication while confessions were ongoing. Monitoring and collecting his statements consumed hundreds of hours and produced over 60 confessions. ISP interviewed inmates and guards and even sent a psychologist to speak with Dr. Walla. Allen showed more than sufficient state action. The state's prolonged pretrial confinement was psychological coercion. And we talked about this the other day as well. It used to be, it was just physical coercion that the courts looked at. Now, as we progressed in our society, it turned to psychological coercion. So, which has started out more direct, like I said, often in a police station or whatever the case may be. And now it's, evolving into how solitary confinement can meet that. And so that's what they're going to flesh out for the court here. Allen's solitary was psychological coercion because it was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature is coercion because solitary confinement can bring a person, quote, to the edge of madness, perhaps to madness itself, citing a Supreme Court case from 2015. This has been recognized in literature, law, and science. Multiple sites for that. Solitary causes psychological trauma, including psychosis, hallucinations, and paranoia. And here
and that's without the Haldol.
Right. And they cite this case, and then they let the court know that inside that case, there's a detailing of scientific studies to support that proposition. And so they're directing the court to look at that. IDOC knew this from day one at WCU. It's Westville, right?
Yeah, yeah, WCU stands for Westville.
Yeah, it's Westville something unit, right? So I'm just going to call it Westville. From day one at Westville, Allen was placed in a, quote, strip cell. the most restrictive cell in the most restrictive solitary unit, with only bare essentials and a camera constantly recording him. And that's why I read that little more details in that Townsend case about how bare the room was there. Soon thereafter, IDOC ordered guards to videotape him when he was out of his cell, including showering and attorney visits. Suicide companions remained outside his door, documenting everything regardless of suicide watch status. He had no contact with anyone unless caged or chained. The sensory deprivation, social isolation, and forced idleness is difficult for even healthy people. Quoting a 2017 study that includes the proposition that a healthy man wrongly implicated and detained in solitary questioned his memory and suspected he committed the crime, thought he stayed sane by reading, exercising, and praying. The experience traumatized him. So that's an example of it happening in another situation, laying it out there for the court. Early videos show Allen pacing his 8x5 by 12 by 5 cell, laying down, doing leg crunches, writing, reading, and looking distressed. And those are the videos from December to March. Within 2 weeks, Allen said he was, quote, broken, and told his wife, quote, if this becomes too much for you, call the detective and I will tell him whatever they want. Tell them whatever they want to know. Had Allen's solitary been 30 or even 90 days, he would not have decompensated, but it was 13 months. The prolonged solitary caused Allen, quote, predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed. Allen deteriorated to being, quote, gravely disabled and, quote, very psychotic. And the IDOC involuntarily administered antipsychotics between April and late June. Although Walla noted concerns about feigning, she diagnosed psychosis and suspected incompetence and overmedication. And Westville only monitored Allen's mental health. Talking with the psychologist while shackled in a cage is not treatment. Solitary put Allen in a constant state of vulnerability. Solitary confinement has long been recognized as psychologically coercive, equated to the rack and thumbscrew and protracted questioning. Chambers v. Florida. And that's where we're saying, back in 1940, that's the kind of coercion they're talking about. But as the years have developed, now solitary has been equated with that same type of abuse and coercion. Pre-trial solitary is, quote, punishment already underway and, quote, conveys, without the necessity of spoken words, the implied threat of further punishment. That goes back to that Townsend case we talked about earlier. It does not matter why a defendant was in solitary, whether justified or whether the prison planned further punishment. And that's obviously, important here because the judge tried to say, well, he was in there for his own, safekeeping. So again, she's expressing a misapprehension of the law. She's misapplying the law. She misunderstands the law. She's, making a mistake of law. Would you agree?
Oh, yeah.
Because she said part of her reasoning was he was in there. This all happened to protect him was the reason. And she actually relied on the reason in her ruling. In this harsh environment, Dr. Walla controlled all aspects of Allen's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could not provide a new window. She could provide a new window and a tablet or strip him to bare necessities. Now, I found this to be a very ingenious argument. I didn't necessarily see it coming. I don't know. Maybe they made this similar argument at trial and I just missed it. But I once we get through it, I'd love to hear more about your thoughts on it. But privileges were contingent on pleasing her. Whether Walla had ill intent is irrelevant. It is what Allen thought and what solitary confinement did to him or would do to many of us. And then they cite another exhibit and says, after confessing to Walla on May 3rd, he asked for his property back, and she indicated she needed more consistency. So what do you think about this argument that they're making here?
That's something I knew nothing about with the whole Walla thing. It's shocking. It is just shocking.
I think it's a great argument. As far as like, this
There's no context for what Walla meant by
right.
consistency. So but
I see
yeah,
how they're trying to play it. And again, what they said is here, it's not whether that's what she meant, it's what Alan thought. And what, so if it's fair to assume that he thought it meant I have to confess more, I have to do whatever they want more, even if she intended more consistency to mean I need to see that your mental health stays stable longer, or that you're not misbehaving, for a longer period of time. The argument here that he thought confessing, pleased her, and his belief in his state that pleasing her was the difference between, getting stripped of things, or getting, some sort of, minor necessity.
no, absolutely.
Yeah. Senator McCain, Senator McCain, a prison camp survivor, explained solitary, quote, crushes your spirit and weakens your resistance more effectively than any other form of mistreatment. So it started with a quote, ended with a quote there, that part. Allen entered solitary confinement compromised. He left broken. Allen's confessions were a product of solitary-induced psychosis, not rational intellect. IDOC, go ahead.
I mean, I think this is just more of the same.
I was going to say the same.
I think we could probably skip over that, but if we can do it.
Yeah, we can do it quick. No, if I did, I would have highlighted it, but we'll just talk about that. That Walla was saying that he was, he had more organized than he has been. He had confusing nightmares, so his confessions to the guard occurred during psychotic and bizarre behavior. Again, that the guards believe he's faking, but they're not clinicians, and that Dr. Westphal found no malingering. Goes on to repeat what he said before about the differences, what he was doing, what he thought. He thought he was dead. He thought the world would blow up if he slept. He thought his water was poisoned. He was reliving the same day. And then he was paranoid of attorneys and staff with Odin patches. That's kind of in there, right?
Yeah.
Something to argue later. On June 11th, he thought he was in hell and didn't understand what was happening. So I highlighted this, which is just basically their overall argument here. State action overbore Allen's will. Allen did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Allen's psychosis was caused by the stress of solitary confinement on pre-existing illness. So, and that's that's the whole crux of that argument. So 2, Indiana Constitution. So all of that above argument was under the U.S. Constitution. Now they're making argument under the Indiana Constitution. The state failed to prove Allen's statements were the product of rational intellect rather than the state's misconduct. The Indiana Constitution also protects against the admission of involuntary statements. Indiana's test is like the due process standard, requiring a confession be freely self-determined by a rational intellect and free will. However, it is more robust because it requires the state prove voluntariness beyond a reasonable doubt.
You want the story of how that standard happened?
I'd love it.
So Miranda came down in 1966, and it said the state has a heavy burden of showing that confession is voluntary. The Indiana Supreme Court picked that up as a signal that it had the heavy burden was proof beyond a reasonable doubt. Colorado v. Conley comes along and says, no, it's a preponderance of the evidence. It takes a while for the Indiana Supreme Court to get the message, but they get it. So as a matter of federal law, they do the preponderance of the evidence, but they kept, as a matter of Indiana constitutional law, proof beyond a reasonable doubt.
And for all of you out there, it's not very typical that a state offers its on these types of issues, that the state offers its citizens sort of more protection than the federal government. So when a state does that, as Michael just described, Indiana does, it's pretty serious, and it should be it's a signal that that's what they want to do for their citizens, and it should be taken, it has a lot of impact. Have you seen it having an impact? Like its application makes a difference. They'll say, oh, well, under the federal law, it would be fine, but under Indiana law, it's out.
Happens with the Fourth Amendment and Article 1, Section 11 pretty frequently. That's the search and seizure stuff.
So then it could happen here in this same scenario.
I mean, for instance, trash searches under the federal Constitution are fine because they're not searches at all. And in Indiana, you've got to at least have reasonable suspicion to go into some trash.
Wow, that's pretty good. All right. Also, it does not require state action to be coercive to overcome a mentally ill person's will. And they cite this State Bank's 2013 case for the proposition that a mentally ill defendant's statement involuntary due to his altered state and confusion, although officers neither coerced him nor knew of his mental illness. So that's a really good, state law. Have you come across that?
No.
Well, it seems like it'll be helpful here.
Oh, absolutely. No, it's a terrific case.
Yeah. But mental illness alone will not render a statement involuntary. There must be some state negligence that contributed to overcoming the defendant's rational intellect. They cite back to Banks and that what happened there. This is what I talk about a little parenthetical that tells them, well, what happened in Banks? That police gave confusing or inadequate warnings. So that was the negligence here. They go on to apply that to the facts here. And they say here, the IDOC refusal to apply their 30-day policy to Allen and to transfer him after he deteriorated is at a minimum negligent state conduct that caused Allen's psychosis and confessions. And the prosecutor's delay and the trial court's refusal to set timely hearings exacerbated the deterioration. This is conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Also, the evidence does not show the statements were the product of rational intellect beyond a reasonable doubt. Allen was considered gravely disabled. He received his last injection through June 16th when he received his last emergency injection due to self-harm. Though Wallace sometimes described Allen as more coherent or his symptoms not significant, the state cannot have it both ways, i.e., Allen decompensated to the point of forced medication, but remained rational beyond a reasonable doubt. And I read that, put that in red here because this is like what I've been screaming. It's like, no, you guys gave him forced medication. You can't force medication on a person unless they meet certain criteria. So exactly, the state cannot have it both ways. What, we just forced medication on him for fun? We thought he was faking, but we forced medication on him? Can't have it both ways, right, Michael?
Not usually.
Even if Allen could occasionally hold a conversation, it does not render his confession voluntary. Anything there before we move on?
Well, I mean, I can say here that, the way maybe it should have gone, and I guess it could be remanded for a hearing on this, but maybe not. I mean, it should be, if you think about it, it should be actually an instant reversal, because by Gull not holding the hearing, not applying the correct standard, the state never proved, and the state never proved that Rick's statements were voluntary. Gull put the burden on the wrong person. Therefore, admitting them without that proof that they were voluntary by whatever standard renders them inadmissible, and we're out of here.
Right. No, I agree. And then you have the also the fact that she, relied on facts that were not relevant to her analysis that we pointed out, where she said the reason that he was in there somehow has an effect on the voluntariness determination. So she's using the wrong standard. She's relying on facts that aren't relevant to that standard. I'd agree. And Jason McClellan says, why didn't they go after Gull for bias? Something you and I have both spoke to. Could this go before her say, the Franks hearing? So this will go before her for the Franks hearing, but some of this other stuff could have also gone into a bias argument. I mean, either she's biased or negligent, like what, she's applying the wrong standard. She's relying on the wrong facts. She's deeming irrelevant things that specifically speak to both his symptoms, intent, and policy violations. Do you think
there's a whole course of conduct argument to be made about judicial bias?
Right. Yeah. I would have liked to see it. I know you would have liked to see it. Then they go on to say, even if the court finds, and I think, Michael, you said in our very first one, like one of the favorite words is even if, was some version of that. So right. Even if the court finds Allen's statements voluntary, they are the product of unconstitutional detention. Allen's prolonged solitary confinement violated Article 1, Sections 12 and 15. That would be of the Indiana Constitution. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. And I think that kind of speaks to what you were just saying before. They consider it kind of along the same lines as due process. Article 1, Section 12 guarantees, quote, for every person, for every injury done to him in his person, remedy by due course of law. Here, Allen was sent to solitary for safekeeping without even a hearing or notice. Even now, I know. So they got right up to chronic and then didn't do it, right?
Yeah, they did it the way they did it. And I'm not criticizing. Look, they have to make the decisions about what they're gonna. I think I said maybe yesterday at the beginning, I'm not going to second guess them about anything they did. I mean, they made the arguments the way they made them. I'm thrilled. We'll get to it in a minute. Thrilled that Glossop and Napoli get a hat tip.
Yep, me too.
There are procedural reasons that, I explained to Mark that I thought chronic should go in, and they disagreed, and they're terrific lawyers, and I'm sitting on the outside.
Right. So here, Allen was sent to solitary for safekeeping without even a hearing or notice. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation of IC section, and they list the sections. Although the court eventually had a hearing on June 15th of 2023, by that time, the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. They cite to this McIntosh case, 2000 case. Just as pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is just one of 6 states protecting citizens from unnecessary rigor. We talked about this before, that neither of us really were aware of this, but so they flesh it out here some. The framers wrote, "No person arrested or confined in jail shall be treated with unnecessary rigor." That's in the Indiana constitutionally. In the Constitution. Typically, this provision requires a, quote, prisoner suffers severe mistreatment. Recognizing this provision applies to solitary confinement, the Indiana Supreme Court stated, "The very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids, as unnecessary rigor, that his confinement should be absolutely solitary, or that all his natural or civil rights should be temporarily annihilated." It's a good case.
Yeah, it's a case that is actually older than dirt.
Right. I was going to say it's an 1860 case. I didn't have a chance to see when the last time it was applied, but
yeah, I haven't looked up, I didn't look up that. I did look up the annotations to Article 1, Section 15, and there's nothing really. There are very few cases. Most of the cases have to do with sentences for people who've been convicted. I didn't find anything, and I'm not saying it isn't there. I looked very quickly at it. I didn't find anything that I thought was particularly helpful.
right. But look, when when your constitution, your state constitution provides the citizens more rights than the federal, you figure out any which way possible to incorporate it into your issues and arguments. Agreed, Michael?
Well, absolutely, and there's been a big thing in Indiana that probably since Chief Justice Shepard, probably since the early 90s, of pushing Indiana constitutional issues. There's the rule in Indiana is that if you don't make a separate Indiana constitutional issue, it's assumed that you're making the same as the federal argument, and it's waived. I've always thought that was odd for a rule for state courts. If you're pushing your Indiana constitutional arguments and development of Indiana constitutional doctrine, you'd say, well, we're going to assume you're making the arguments under the Indiana Constitution. If you want to make federal arguments, you better separate those out.
Right.
And it's interesting. I mean, Mark and Stacy have done here what lawyers typically do. They do first the federal question and then the Indiana constitutional question, because I would have, and I'm not saying they're wrong to do it. It's very standard, okay?
Right.
But
Absolutely.
I'd lead with the Indiana issue. It's a better standard. You're more likely to win.
Right.
And if you don't like the Indiana standard, here's the federal standard.
Right. I mean, they do the same in Illinois. If you don't make a separate specified Illinois constitutional argument, it's waived and they're going under the federal. But I think it's, for the most part, because of what we were saying to everybody earlier, that most of the states are in lockstep with the federal constitution. So it's unusual when the state's either constitution or their law, around an issue is not in what they call lockstep with the federal courts, meaning, it's not the same as what they would apply in a federal court. So, here comes a separate argument, and if you don't dot your I and cross your T, they may say that you waived it, which, yeah, and when you're thinking about it, is odd in a state court scenario. But I guess it's because for the most part, there's so much in lockstep. I don't know. Although it seems like you guys have a lot of stuff, maybe not.
Indiana does have a number of things that are different from the feds. The right to counsel attaches earlier than under federal law. I think there are more differences as you go out in the states. I don't know about Illinois, but I think there are a lot of differences in a lot of states from federal constitutional provisions. Maybe not huge ones, but
Right.
I mean, generally the Fourth Amendment, generally Indiana Section 1, Article 1, Section 11, the search and seizure provision, which says the same thing. The difference between Article 1, Section 11 and the Fourth Amendment is in Article 1, Section 11, there's a semicolon where there's a comma.
We have the word privacy in ours where it's not in
Right.
the federal. So I'm always trying to rely on that to get something. That's why what I'm telling you guys is like, if there's any difference in yours, you say there's a reason. And if you can't find it under the feds, find it under our state constitution.
Well, and I'm convinced. I mean, I haven't been able to win the argument, get the argument up again. But I've looked at the debates of 1850 and 51, and the journals for the Constitution in 1850, and it's 50 and 51, and it's pretty clear that the right to a jury was intended to be a right to a 12-person jury in all cases, not just felonies. At the moment, Indiana law is in lockstep with, as you put it, with the federal Constitution. You only get a 12-person jury in felonies, not in misdemeanor cases. You get a 6-person jury.
Right.
But you dig into the history and you make the arguments for your state's constitution being different from the federal Constitution.
And they continue to do that here, fleshing out the rigor argument. Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the, quote, act or instance of strictness, severity, or cruelty. And they quote the dictionary for those words. When Allen started suffering from confusion, memory lapses, paranoia, and bizarre behaviors, there was no longer a risk he could handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evident on the videos where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical, too. They cite to this Williams case, and here's a parenthetical. Solitary can result in physical harm, inducing self-mutilation, as well as a maladaptive coping behavior. Allen lost 40 pounds, was unable to care for himself, was tased. His face was black and blue and at times bleeding, and he was poisoned by fecal matter and toilet water. Indifference to his catatonia was shown where medical staff discussed blood pressure and cholesterol with a vacant Allen. And they get into that some more later, so we'll hear some more of that. This psychological and physical pain was unnecessary. IDOC could have transferred him upon deterioration as policy requires. Even an isolated infirmary cell would have been better than, quote, the hole designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. So now we get to the constitutional violations require suppression. So over 150 years, the degree of civilization in a society can be judged by entering its prisons, quoting Davis. In 2015, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting, "There is truth to this in our own time." Applying the exclusionary rule to these constitutional violations would deter abuses with our prison system and law enforcement, protect judicial system integrity by showing it condemns such conduct, and protect the human dignity of those unable to make bond while awaiting trial. They cite to an Indiana case where they excluded a confession that was the result of physical abuse in solitary, in part under Article 1, Section 15. Now, I highlighted this because not all constitutional violations require suppression, trigger the exclusionary rule. And that's what obviously they want to do here in making their argument that this is the type, even if it hasn't been applied in the past, that should the exclusionary rule should apply under the Indiana Constitution. This quote here shows that the courts have done that, at least under Article 1, Section 15. So they're going on to explain how Indiana has a robust exclusionary rule. Relying on Article 1, Sections 11, 14, Indiana adopted the exclusionary rule long before the Fourth Amendment exclusionary rule applied to the states. Under the exclusionary rule, to determine whether a statement is the product of illegal detention, the court must ask if the statement has been come by exploitation of that illegality, or instead by means sufficiently distinguishable to be purged of the taint. So we talked about this, Michael, you raised this earlier about attenuation. And, I also, before we get into that, have you seen Indiana actually applying a robust exclusionary rule where something gets excluded that would not have been excluded under the federal Constitution?
Yeah, I think I gave a good example earlier, trash searches.
Oh, yes, you did. So now you talked about attenuation and, that being, that something has, well, I guess I'll just continue to read because it goes on to say what they consider. The court considers 1, the elapsed time between the illegality and the acquisition of the evidence; 2, the presence of intervening circumstances; and 3, the purpose or flagrancy of the official misconduct. First, Allen's statements occurred during the illegality of his detention at Westville. Second, there was no intervening circumstances. Again, there is a well-known connection between solitary confinement and psychosis/delirium. Third, the constitutional violation was flagrant because IDOC violated its own policies for keeping Allen safe, and the court and the prosecutor refused to help when Allen's attorneys warned of his deterioration. Even if the court finds Allen's statements were voluntary because he was not interrogated by law enforcement, so that's interesting because now they're tying it to that, which was one of my concerns, and they're raising it even though they made a separate voluntary argument, with it not having anything to do with being interrogated. Why do you think they tied it in there?
I don't know. I think they've misstated it here, that they really didn't want to say that, because the next sentence goes on to say, as such, his free will did not purge the taint. Oh, okay. So they're saying his free will. So
meaning, I think his free will of talking.
If you don't like voluntariness, it's illegal detention.
Right. So he was not interrogated by law enforcement. Okay, I'll start over. Even if this court finds Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. So I think what they're doing here is sort of like fronting the argument they expect from the state, and they're talking free will of he was on the phone with his family. I'm assuming, is that what they're talking about?
I think they're trying, there are two arguments. If you don't like, it's a little bit like the boats being blown up in the Caribbean. If we're at war, it's a war crime. If we're not at war, it's murder.
Right. So, and they end with the trial court erred by denying the motion to suppress. The error was not harmless. Before a federal or state constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. Citing one U.S. Supreme Court. Is Torres v. State? No, in Indiana. Is that a Indiana Supreme Court or just a?
Yeah, that's Indiana Supreme Court just following Chapman.
Okay. Quote, no piece of evidence may have greater sway over a jury than a defendant's confession. The erroneous admission of statements to Dr. Walla alone was prejudicial because they were a large part of the state's case. The prosecutor particularly concentrated on Allen's May 3rd statement, arguing that Allen knew a fact only the killer would know. The confession also countered Allen's confident and unwavering pretrial protests of innocence. And that ends their section on the what should the reasons why the confessions should be out. And what do you think?
Be very interesting to see what the next thing is, to see what the state has to say about it all. I have some ideas, but I'm not going to share them
Right.
because I'm not going to give the state
Give the
any
state any
ideas.
ideas. Right. I was thinking about that. Like, maybe I should watch what I say because I want to give I don't think the state's I don't know. But all right, we move on.
Hey, we've been at this about 2 hours and taking care of the statement part. Maybe we need to do. I don't think I can make it through the
Section 3.
the third party stuff right now.
All right, we'll save section 3 for a part 4. And let me just see before you go if there's any questions that
yeah, happy to take.
Let's see. So Belly Mayday said, so does a retrial mean that his conviction is overturned automatically, or does it mean that, or does this need to be explicitly requested? Thank you guys so much.
So if they reverse his convictions, then it'll be up to the state to decide whether to retry him.
Right. And they are asking that his conviction be overturned. I don't know. Is that not in the wherefore clause at the end?
Yeah, I think it's at the end.
Yeah, I'm sure that they're appellate Richard Allen requests this court reverse his conviction. So thank you. Appreciate your comment. Jason says, thanks for your great coverage. David James says, if he gets another trial, would he be released? Is there bond after an appeal? On a capital case?
He could get bond. It's not likely. I mean, he could get, he could get a bond so high that there's effectively no bond. That's probably what would happen.
Laura Lee Annie says, Doug Carter is creepy. Could he be involved?
Yeah, he's retired. I don't think he'll be involved in round 2 if there is a round 2.
Right. And then I think you went through this. I don't know if it was 2 lives ago or the 3rd live. Roosevelt Media News says, how long before Allen has a hope of being free?
Hard to say. I mean, I think this appeal, I don't think the appeal is going to be finished. And I mean finished through the Indiana Supreme Court before 2027. And then it took 2 years to get Rick to get to trial after Rick was arrested.
Right. And if they're going to allow all this other evidence that they excluded, now the defense and the prosecution both have to work on gathering and getting those people, and the prosecution looking into it. Who knows?
Yeah, and it may not be the same lawyers, so they have to have time to get up to speed on all the 20
Lord.
terabytes of discovery.
If it's new lawyers, that's a whole nother 2 years built in right there, probably.
Oh, it's almost certainly going to have to be new lawyers.
Wow. Scary thought. Scary thought. Well, Michael, thank you so much for joining us. Thank you, all of you, for being here. We'll figure out when and how to do a part 4 to finish this up. and enjoy the rest of your weekend, Michael. Thanks for doing this.
Thanks. Mary.
All right, bye, guys. See you next time.
Bye.
Bye.
Appreciate it.